Thank you, Mr. Speaker. I'm pleased to be able to finally have an opportunity to speak at more length about this issue. I won't go so far as to say that I'm pleased at the opportunity, because I think that the fact that this bill is coming into this House today is, in my view, it's very disturbing to me as a member of this Assembly, and in some ways I'm quite sad today, actually, that I need to be in the House outlining the significant concerns that exist around elements of this piece of legislation. What should be a time for a significant portion of Albertans to celebrate a long-awaited for symbolic recognition of their equality has instead turned into this debate, which, in my view, undermines the impression of Albertans to the rest of the world, undermines our own collective commitment to education and to diversity and to a full, thoughtful discussion of things, and ultimately undermines the very new right which we are in the process of being about to recognize. So let me just talk a little bit about that. Obviously, the key issue with respect to this bill is Section 11, and that's, of course, the part of the bill that would allow parents to opt out of or have their children opt out of instruction that it deals explicitly with religion, sexuality, or sexual orientation. And it is this particular section which, in my view, represents a very dark day in the history of this province. Let me talk first about the issue with respect to religion. Now, I respect the right of parents to choose what religious instruction their children will or will not receive. Personally, I would prefer to see a system where all children were given a very neutral survey course of what religion looks like in different types of religion. That's my personal belief of what would represent the most enlightened approach to educating my children. But I understand that my belief is not everyone's belief. And I appreciate that some people feel very strongly that they don't want their children's religious instruction that they receive at home and and their beliefs, it goes beyond just instruction, to be challenged in the school setting. So that's fine. But Section 50 of the School Act deals with that issue. It deals with that already. The School Act talks about education. The School Act talks about parents' rights in relation to their children's education. The School Act talks about that whole milieu. And so it is not necessary to put that provision into the Human Rights Code, because the Human Rights Code is not a document designed to undermine the very rights which are included in the Human Rights Code. It is not a document designed to, as the member from Chester Mayor talked about, to bow to every different person's version of what is politically correct today or tomorrow or the next day. It is a set of rights that we, presumably, all agree all people have. And so I'm very concerned about muddying the waters with a statement that we are prepared to undermine some of those rights in certain circumstances. Now, I'll talk a little bit about how it is I believe we're doing that, but I want to just stay for a moment on the issue of religious instruction. One of the problems with putting this into the Human Rights Code and taking it out of the School Act is that you make it a human right, and with that comes a whole slew of legal consequences and implications. It allows for a broad range of interpretive efforts to be applied to it. So what we're putting in it right now could be amended through a great deal of litigation in the future, and because it's an active right which is found in the code, it will be treated differently than what's in the School Act, which is essentially an administrative provision. So right now in our schools, what theoretically happens is, if religious instruction, and of course the School Act only talks about religious instruction, the School Act does not allow parents to pull their kids because somebody talks about the dreaded sexual orientation. But let's just say for a moment we're talking about the issue of religion. If religion is brought up, the family needs to get notice. Well, that's fine. What does the notice ultimately look like? At the beginning of the year, can the school board say, from time to time in grade 12, the social studies curriculum will call on the teacher to engage in discussions that will cover issues that may cover religion, that may cover theories of evolution, that may cover philosophical discussions which have implications for certain religions, which may cover the concept of, for instance, gender equity and gender equality. And if they give that notice, is that enough? Can the parent then simply provide the notice to the teacher, and then every time those issues come up in the teaching moments that we've talked so much about, the teacher just says to the child, you have the option now to leave the room because we're talking about these issues. Is that the way it would work? Well, now that it's in the Human Rights Code, it is entirely possible that the parents would be able to go and say, well, this right that you're giving me is meaningless if it's administered this way. So, in fact, what you need to do is give me notice every time it's going to happen. You've got to give me dates. You've got to give me content. You've got to give me written curriculum, because otherwise this right that you've now given me in the Human Rights Code of my province is meaningless.